SwayamPrabha. Digital India. Educated India.
Welcome students. Myself Dr. Amarendra Kumar Ajit, Assistant Professor of Law from Faculty of Law, University of Delhi. Today I am going to deliver 8th lecture of Transfer of Property Act. In 7th lecture I have discussed the rule of election and apportionment. So in 8th lecture I am going to discuss the limited power of transfer and restrictive covenants. This is a unique kind of provision which has been specifically mentioned in cases for special cases only, where there is a very limited power of transfer. Okay. So, this is not an exception, but it is a general rule that in certain cases there is power of the transferor has been limited according to certain interest or certain conditions. So, if he is going to do that kind of the transfer, then what will happen? And second is restrictive covenants, that there are certain kinds of limitation on the land, on the immovable property, which will always carry in successive transfer. Okay. So, these things I am going to discuss today, which is the main focus of this lecture. So, the topic covered would be limited transfer power, legal necessity, ownership and contractual obligation. So, first I will come to limited power of transfer, which is given under section 38 of Transfer of Property Act. So, if we will go through this section 38, it has a very specific feature which says that the transfer of property where the interests are very limited, okay, then the power of transfer in respect of that immovable property will be dealt by this section. The power of transfer is available only under specified circumstances. What are those specified circumstances? That in certain cases only this transferor would enjoy that kind of right to transfer the immovable property. Okay. That means, here a kind of things has been kept, that he is a kind of person who is burdened with certain kinds of responsibility, and only in the legal necessity, that means only in the specified circumstances where this law allowed, only in that case he will be transferring the immovable property and he will have to justify for that. But if the transfer is happening, then what are the rights and obligation is going to be created for the transferee, that is more important. So, for that purpose this section is. So, mainly this section discusses about the transfer by Hindu widow or transfer by Karta of the Hindu joint family, or transfer by the guardian of minor, okay, guardian of minor. So, these are the specific circumstances where they are bound by number of responsibilities. That means, they are working towards certain responsibilities, and when there is a requirement to transfer on the name of legal necessity, then only they can transfer those property, otherwise they are not allowed in that way. Okay. So, they are not independent to transfer transfer that immovable property at any time as required by him. No, it is a necessity of the person who are related with that person under in any capacity, okay, whether it is a Hindu widow or whether it is a karta or in case of guardian. So, section 38 is a very limited scope, but there are two exceptions of it which say that this section does not apply under section 41 of the TPA, which talks about the ostensible owner, and that is the things I am going to discuss in the next lecture, specifically section 41. So, if the transfer has been done by the ostensible owner, in that case it will not apply, or the case is covered under section 64, that is the purchasing in good faith for consideration without notice of a trust under the Trust Act. So, that is a kind of exception under this section itself. So, here what is very important, that the person is only entitled in a specific circumstances, and one thing is that it is for only immovable property, because whatever we have read up to section 37, it was applicable for this movable as well as immovable, but this section onwards it is going to apply only for immovable property under this part. Okay. So, what is necessary here is the person must be bound by those circumstances, person is holding that immovable property and alleging the existence of those kind of circumstances. Then the section declares that as between the transferor and the transferee and other affected by the transfer, such circumstances shall be deemed to have existed. That means, shall be deemed to have existed if the transferee, that means the person to whom it has been going to be sold, had taken the reasonable care to ascertain the existence of those circumstances and acted in good faith. So, these two factors are very important in this case, that whenever there is that kind of the transfer under a special circumstances, that means person, the purchaser, the transferee was well aware with means that means he had knowledge about it, that there is existence of that kind of circumstances, and in that circumstances he is selling it and he is accepting that offer, that means he is purchasing that one under the good faith, then his interest will be protected. So, in simple words it can be said that where a person is authorized to transfer a property in certain specific circumstances which are of variable nature, the actual existence of such circumstances is not necessary. It is sufficient that the transferee had used reasonable care to ascertain the existence of such circumstances and acted in good faith. That means, this reasonable care to ascertain the existence is not up to that extent that every minute detail must be known to the transferee. That is not important. Only important thing is that the person has taken care about that, okay, this kind of the circumstances he is selling it, but he will not go beyond that what is actually whether this circumstances in existence and not. So, he will not make an inquiry of it first of it. Okay. So, there is no necessity of making a detailed inquiry by the transferee, but only reasonable care has been taken that, okay, this kind of the circumstances are, and he is working under those circumstances and selling those property, immovable property, and he is purchasing under good faith. That means, there is no such kind of the fraudulent intention from the either side. In that case, then the property will pass to the transferee. So, the principle underlying this section was laid down by the Privy Council in Hanuman Prasad versus Mushammat Babui. What was said in this case? That the power of a manager for an infant heir to charge an estate not his own is under Hindu law a limited and qualified power. Okay, that means a karta. it can only be exercised rightly in case of need or for the benefit of estate. Case of need or benefit of estate. Their lordship think that the lender is bound to inquire about the necessities for the loan and to satisfy himself as well as he can with reference to the parties with whom he is dealing. The manager is acting in particular instance for the benefit of estate. Okay. That means, it is for the benefit of the estate or benefit for the person or benefit of the members on the behalf of which is acting. That is important. Okay. Suppose estate is there and now it is under presumption. Suppose there is a land part near to the river and he is under presumption or supposition that this part is going to the part of the river in next few years. Okay. So, that land will not remain. So, in that case he want to sell it early or he want to dispose of that and he want to take the money of that, then he can do that, for it is for the betterment of estate. That means, he want to get the money as early as possible from that. Or if there is a certain other necessity, that means for the education of minor, marriage of any member of the family, if he is a karta, or in the case of guardian, if he is spending on the any kind of treatment, medical treatment and all. So, for these kind of legal necessity, these person are allowed to sell, allowed to transfer. It is not necessary that always sale. Here the transfer means that is mortgage, that sale, or even in lease also it may be included in this. Okay. So, these are the essential requirement that is has been called in law as a legal necessities. So, only in legal necessities it can be done, transfer can be done. Then one illustration has been given here that a Hindu widow whose husband has left collateral heirs, okay, alleging that the property held by her as such is insufficient for her maintenance, agrees for the purpose neither religious nor charitable to sell a field, a part of such property to B. That means, she want to sell for her own maintenance and B satisfy himself by reasonable inquiry that the income of the property is insufficient for age maintenance, but this inquiry will be not the detailed one, just only think that certainly she is not able to maintain herself, that is sufficient, and it may be just inquired by the neighbors or if he is in villages, then any person of village may discuss the situation, he may discuss and he may identify that okay, she is unable to maintain herself, that will be sufficient, and that sale of the field is necessary or necessity. So, acting in the good faith buys the field from A, as between B on the one part and A and the collateral heirs on other part, a necessity for the sale shall be deemed to have existed. Okay. That means, after this short inquiry, if B is able to find that okay, there is a reasonable requirement, there is a necessity that she is unable to maintain herself and want to sell this property, then he will take that property, he will, that means the transfer will be done, and by that transfer everyone will be bound, that means collateral here will be also bound, and subsequently if there is a claim from the side of the B's here, okay, that means something happened to be, in that case also B heirs will be also legal authority to take any suit or any action if something has not been satisfied, or the this A legal heirs are bound to comply with those things. Okay. Then essential requirements. Okay, what are the essential requirements of this? So, there are 6 requirements under this. First is that there must be limited power of alienation. This is the first requirement, limited power of alienation over the property, and property will be immovable property. Okay. So, limited power is by default is this, that means limited power it attached, it is not going to be added in this. Okay. Already there is a limited power, and that limited power transferor is going to transfer. So, limited power of alienation over the property transferor have. So, this transferor is under a special circumstances authorized to transfer the property, and these special circumstances are generally variable in nature. It may happen anything. I told you that it may be the marriage, it may be the disease, okay, it may be the education. So, it is not certain. Only thing is that it should fall under the legal necessity of the person, okay. For that purpose this property is, and the transferor will do the transfer for the benefit of them. So, in that way circumstances may vary. So, that limited power of transfer may exercised in that legal necessity. Then transferor must transfer the property for consideration. That means there must be consideration of the property, because for what purpose it is going to be transferred? For the money only. Okay, that means there is a requirement of money, or they want to save the estate, both the things. So, in that case even though they want to save the estate, that is betterment of estate, in that case also there is a requirement of money, and in case of this necessity, that can also be done. Okay. So, in case of legal necessity also there is a requirement of money, and in other, that is for estate, there is a requirement of money to save the estate. So, in that way there is a legal necessity for this consideration. So, it cannot be gratuitous transfer without consideration. Consideration is must in this case. Then transferor must allege the existence of special circumstances at the time of transfer. That means transferor must allege, that means he will say that these kind of the condition are in existence, and for that purpose we require money, and I am going to sell it or transfer it using the right of this special alienation power. Then the transferee must use reasonable care to ascertain existence of such circumstances. Now, it is the duty imposed on the transferee that take the reasonable care of it. I told you that only the reasonable inquiry is required. That means at least why this reasonable inquiry is necessary here? Only to prove that there is a good faith behind it. Okay. Good faith is a term, that means whatever the transaction is happening, it is not a kind of fraudulent transfer, or it is not a kind of collusive transfer. Okay. That means sometimes it may happen that this person who transferor and transferee have a certain motive behind that transfer, and they are doing it. No, that kind of the things can't happen in this case. Otherwise, this transfer will be not treated as a proper transfer, it will be void transfer at all. Okay, void ab initio. So, in that case transfer is required to be done within those circumstances only. The transferee must have honestly believe in the existence of those circumstances. Okay. After taking reasonable care of it, that honestly believe in the existence of those circumstances. This honestly belief is the good faith. Okay. When the transferee is believing himself that okay, now these are the circumstances, I have inquired about all these things, and I found that okay, these circumstances for under the reasonable condition, it is not, I am not saying that a detailed inquiry is not necessary at all, that sometimes it may happen that the person is showing that kind of the circumstances, person have other source of means also, but he want to sell the property first of all and want to exhaust this. Okay. So, there is no requirement on the part of the transferee to see that whether there are the other sources or not, and how he is going to do. Only thing is here is to identify the circumstances, whether these circumstances in existence or not. Being a reasonable man, what a transferee can do, not beyond that. A reasonable man here means that a reasonable circumstances, that means he will ask to someone else, okay, those who are living in his or her neighbor, then he will ask to the village people, and if he is according to his satisfaction, being a satisfaction of a reasonable man, any reasonable man can say no, in these circumstances this kind of the situation is already in existence and he or she needs that transfer, then that is sufficient. So, here it has been said that honestly believe after those going through those inquiry that okay, there is the belief of that circumstances. So, this gives a kind of good faith that whatever he is doing under the good faith. There is no ill motive, there is no certain things behind that transaction. So, in that way this transaction will be the valid one. The next point is about this is the protection of transferee, which is the main you can say the objective of this, that in those circumstances if transfer is going to happen, okay, then the right of the transferee must be protected, because ultimately transferee is protecting under good faith. So, when he is doing all these things under the good faith, then certainly this transfer should not be treated as void transfer. Okay. So, for that purpose this protection is that. So, this section protects the transferee. It is sufficient that the transferee use reasonable care to ascertain the circumstances alleged by the transferor and acting in good faith, honestly believing the existence of those circumstances. So, example is there where a guardian of a minor property mortgages the property alleging legal necessity. In the mortgage after bona fide inquiry find the existence of necessity, then he will be protected even though he may not be able to see where that money is going to be used. Okay. So, I told you that there is no requirement of detailed inquiry and the post inquiry also, that is post transfer inquiry also. So, that is not the case. Once I was that being a transferee was satisfied that this kind of the real circumstances is, then transfer will be valid. Where that money is going to be used by the transferor, on the name of necessity who took this money, who did the transfer, but now he is going to use for the personal gain and all, then that is not the concern of transferee. Transferee role is only that he has used his reasonable mind as well as done the act in good faith, that is sufficient, then the law will take care of it. Okay. What is the role of the transferor here? What is the later on the transferor is going to do the transfer money? That is immaterial for the transferee. So, the interest of transferee has been protected here in this way. So, it is for the court to see the existence of legal necessity, that transferee has no means to determine its existence. Okay. So, if something will be disputed, then the court is authorized to see whether the proper legal necessity was in existence or not the transferee. Transferee will take only care as a reasonable person. Okay. That is sufficient. If matter will go before the court, then court will take the all documents, okay, all evidences, that whether all property details, that okay, was there this necessity really existence at that time, or it was just a kind of created things, or it is an implanted type of the necessity. If that will be the case, then also it will be not void, because he has taken the reasonable care. Okay. Reasonable care. Only the part is that if he has not taken reasonable care and not done in the good faith, then transfer will be invalid. So, something is happening on the part of the transferor, it is not going to affect the nature of transfer, transfer will be valid. Now, next is related to right to maintenance and advancement etc. under section 39 of TPA. So, according to section 39, it says that where a person has right to receive maintenance, a provision for advancement or marriage from the profits of immovable property, which is the subject matter of transaction, and such property is transferred, the right may be enforced against the transferee. Rights may be enforced against the transferee if he has a notice of the burden of the property and transfer is gratuitous. So, in that case transferee will be responsible for that burden, but not against a transferee for consideration and without notice of the right, nor against such property in his hand. So, what is the meaning of this? The meaning is very clear, that we will go through this. it says that this section lays down that where a third party has a right to receive maintenance or a provision for advancement or marriage out of the profit of immovable property, which is subsequently transferred, the right of such third party can enforced against the transferee. So, how we can understand this? We can understand in the way that A is the transferor, okay, X is the property on which B has certain kinds of right like maintenance or advancement or marriage and all. That means, all expenses related to marriage and all that can be used by the benefit of this property from this property itself. Okay. So, if A is transferring this, to C, and in that case B had that kind of the right over that. So, what it says that this transfer, that means when A is transferring to C, then in some case this B will have right. So, what are those conditions when B will have right even though it has been transferred by A to C? That means, property is going to C by the transfer of A, but B will have right over it. So, what are the conditions? So, that is going to be explained here. So, it says that B can enforce, that means it says that the right of third party here is B, can be enforced against the transferee, transferee is here C, because the property is going to C, the C is transferee, A is transferor, B is third party, X is property. So, if the transferee had notice, C had notice that on X there is certain kinds of liability. Certain kinds of liability means here that B had that kind of the right to take benefit from the land X. Okay. So, this notice was with C, notice of maintenance, advancement or marriage, whatever it may be, although the transfer was for value and or consideration. So, there was notice plus it was for consideration. That means, C was knowing this and knowingly he has purchased after giving money, that means giving this consideration, then C will be liable. Or if the transfer was gratuitous, that means there are two conditions for C. First, that there was notice plus there was consideration, and second is that is the transfer is gratuitous. So, in that case gratuitous means that is without consideration, irrespective of the fact whether the transferee had notice of the right of maintenance or not. Okay. So, in case of gratuitous transfer, notice is not necessary. This is not necessary. That means, if the transfer is gratuitous, that means A has given this property to C without taking any money, then even in that case C will be responsible. Okay. And in case in the first that C had notice of this kind of burden plus he has given money to A, even in that, because in the first case there was knowledge. So, knowledge, after knowing the things he has given the money, he has purchased the property, liability will be transferred. But in case of second, it says that even though you have no notice, but because you have not given money, it was the consideration free transfer, even in that case C will have liability. So, it is very clear in this case under this section 39 that the transferee will be always liable in these two conditions. So, question here will be that when C will be not liable, this Mr. C, in which condition he may not be liable. This is the condition of liability. So, C may not be liable when, that means he had paid this consideration, that means he had paid this consideration and there was no notice, that means he was doing under good faith. So, C if purchase the property after giving consideration with without notice under good faith, then C will be not liable. C will be free from all those liability which is already on X property. Okay. So, this is the right to maintenance over the property. It is a very limited right, but it is a very important one. Okay. Then main important point is the restrictive covenants. Section 40. According to this section, this restrictive covenant is a kind of a special circumstances. Okay. What is the restrictive covenant? First of all, restrictive covenant is a kind of restriction over the property. Okay. What kind of the restriction? That this restrictive covenant is that kind of the restriction imposed by the transferor, which is going to be followed by the subsequent transferee always. Subsequent, that means how many ever transfer will come later on, all the transferee is bound to follow those conditions in that. Then it is restrictive covenant. It is not only for the first generation, that means for the first transfer and transferee, but for the subsequent transferee it will follow. Okay. So, it is always related with the interest of the transferor, first transferor, or it is related with the interest of the property. In that way it is created. So, this restrictive covenant got a special place under Transfer of Property Act. So, according to this section, where a third person has for the more beneficial enjoyment of his own immovable property and independently of any interest in the immovable property of another or any easement thereon, a right to retain the enjoyment in a particular manner, or is entitled to the benefit of an obligation arising out of contract and annexed to the ownership of immovable property, but not amounting to an interest in or easement thereon. Such right or obligation may be enforced against the transferee with a notice or a gratuitous transferee of the property affected thereby, but not against the transferee for consideration and without notice of the right and obligation, nor against such property in his hand. Okay. So, we will see here that how this covenant, that means any condition which is beneficial for the enjoyment of the immovable property of the owner itself, that is the transferor, first transferor, how it is going to protect the interest of it, because it is always for the protecting the interest of the transferor, because without that protecting the interest, there may be possibility that transferor may not enjoy the property properly, or it may not be beneficial for the property itself. So, sometime interests are related with the property and that must continue for the subsequent transfers also. So, that is restrictive covenant. So, first of all, what is the meaning of covenants? Covenants is say the written agreement or contract with respect to a property, where the covenant restrict the use of enjoyment of the property, they are known as restrictive covenant, whereas they require to do some act as they are called affirmative covenants, but where there is a restraint from doing certain things, they are called negative covenants. Okay. So, this affirmative covenants or negative covenants. In affirmative, you will have to do certain things. Okay. That means the transferee will have to do that. Suppose take the example that the something has been transferred and it is also related to immovable property. Section 40 is also related to immovable property. So, when any transferor is transferring immovable property and he is saying that okay, I have transferred this campus, I have transferred this particular property to transferee, but transferee will maintain the garden or will trim the tree every year or at least in a 2 year regularly, Okay. So, maintenance of this part, which is the positive part, has been given in the covenant itself. So, the transferee will have to maintain in that way. Okay. Otherwise, this is called a positive covenant. Negative covenant is that if there is a certain drainage system, okay, and that drainage system is a common for the transferor property as well as which is going to be transferred to the transferee. So, if it is the common drainage, then there may be agreement within transfer agreement in which say that there will be no destruction of the drainage system in future, and this property is being transferred on the condition that this drainage system should be maintained properly. Okay. So, this will be the a kind of negative covenant, that it should not be told, it should not be removed at all, or it should not be touched at all. Okay. Why? Because without drainage system, transferor will not enjoy his own property. So, that is the requirement of this. In same way, it may happen that okay, I am transferring this building, a part of transferor building itself, but certain constructions should not come this side in future. Okay. So, that is also a kind of negative covenant, that the transferee will not make that type of construction, which will hamper the enjoyment of the right of the transferor. So, this is the kind of negative covenant. So, section 40 deals with the negative covenants, okay, and their enforceability against subsequent transferee. This section says that if the transferor imposes a negative covenant in a transfer of property, then such covenant is binding and enforceable against assignee of the transferee, provided the following conditions are fulfilled. What are those conditions for that? First of all, that the covenant is for the more beneficial enjoyment of the transferor's own immovable property. More beneficial enjoyment for the transferor's own. So, this is the prime consideration. That means transferor interest, that means enjoyment of the property of the transferor is going to be hindered. So, okay, in that case, if it is going to be hindered by the transferee in future, if there is a suspicion, then certainly the transferor will make that kind of the condition. So, for the better enjoyment of the property of transferor, this condition is generally imposed. So, that means transferor cannot impose any condition, that means open condition, that okay, you cannot do anything. Okay. That means you cannot make a garage on this land. If the making of the garage is not going to affect the right of the transferor, then it will not come under this one. That means it will be not a restrictive covenant. Okay. So, in that way, this is the kind of restriction. Restriction is that only those covenants are valid covenant under this restrictive covenant, which is for the enjoyment of the transferor property, for the better enjoyment of the transferor property. So, the subsequent transfer is for value and assignee has notice of covenant. That means it has been transferred, subsequent transfer, that means property has been transferred to B, B is transferred to C, C is transferring to D, D is transferring to E, like this. So, all this transfer are with consideration, with money plus notice of those restrictive covenants, because generally it is used to be in the agreement itself. Okay. Agreement itself. That means this agreement is going to continue. The whoever will purchase, first of all he will see the agreement itself. So, in the agreement itself, it will be always mentioned that this thing should not happen in future. Okay. So, this will go parallel to that. So, through that there will be notice to the purchaser. Whenever he is going to see the earlier agreement, that what was the right of the transferor. So, he will go through the earlier agreement, and through earlier agreement it will be very clear that there is a restrictive covenant over this property. So, in that way, after this notice and with certain consideration, if he is going to purchase that property, then that person, that transferee will be responsible to follow that covenant. That means he will be bound to follow that restrictive covenant. The subsequent the subsequent transfer is with this without, or subsequent transfer is without consideration. What it says that the provided the condition are fulfilled, the subsequent transfer is for value and assignee has notice of that, then only it will be or. That means, then F is bound to follow. Okay. F is also bound to follow if E is transferring, without money. So, if something has been transferred without money, in that case notice is not required. The meaning simple is that something has been just transferred without any consideration. So, it may be the possibility, okay, it may be possibility that it has been a kind of gift, or it is a kind of something else, or there is a certain motive behind that, how to save it. So, it has been said that in that case this will be also binding in nature. Binding in nature, that means, first of all you have knowledge plus consideration, and second condition is there is gratuitous transfer without consideration. So, ultimate purchaser will be bound by the restrictive covenants. Okay. So, when there will be a condition when this person will be not bound by that. Okay. When there will be condition that F will be not bound by those condition. That means, when he has purchased this property for consideration and acted in good faith without notice, okay, then covenant will be not binding. So, that will come. So, restrictive covenant are annexed to the land as if they are the part of the land, and along with the transfer of land they pass to the every subsequent transferee. So, I told you here that it will if A has put a restrictive covenant over the property X, then it will pass from B to C, it will pass from C to D, D to E, E to F. Only condition is that all this transfer must be with proper notice of this covenant as well as with consideration, or if there is a certain gratuitous transfer at any stage, in that case also it will pass. So, section 14 enacts the equitable rule that the burden of a covenant runs with the land. Okay. This is equitable rule. Therefore, such covenants are enforceable against any person who has an interest in that land. So, the affirmative covenants are not annexed to the land and do not run with the land. This is also very important. Only negative covenants run through the land. Okay. Affirmative this covenant means the positive covenants, just I told you. So, the subsequent purchaser will not be bound by that. Okay. So, it will not run through the land, it will be effective only for the first one. So, if there is the case that if there is a positive covenant, so it will be effective only up to A to B, but C is not bound by these those affirmative covenants which has been created by A at the time of dealing with B. Okay, and not it will continue to the subsequent transferee. But if it is negative covenant, it is a restrictive covenants, then it will go to the F. Then covenants running with the land, it says that this expression is borrowed from the English law of real property. The covenant running with the land is a covenant annexed to the land, and covenant may run with the land at law or in equity. So, what is that? The covenants run with the land at law when the benefit of it passes to a assignee of the covenantee, or when the burden of it passes to the assignee of covenanter, and in either case independently of notice. Okay. So, covenant at law and covenant in equity, these are the two different terminology. So, it says that covenant runs with land at law, that means through the legal protection through law, when it will be presumed that benefit of it, that means benefit related to land, passes to the assignee of the covenantee. Passes to assignee of the covenantee is there, that means subsequent one, and when the burden is burden of it passes to the assignee of the covenanter. Okay, like this here. covenanter is this, okay, and covenantee is B. So, it has been said that when the profit, this profit related to land is going to be accepted by the assignee of B, and if there is a burden, then in that case assignee of the covenanter, then it is called, it is a kind of covenant at law. But what equity says? Equity is very clear. When the burden of it can be enforced against assignee of the covenanter, when the burden covenant runs with the land in equity means if there is no law also. So, equity protects that interest, and equity protects that interest is that the burden of it can be enforced against assignee of the conventor. Okay. So, whoever is conventor here in any kind of this agreement, whether it is between A and B, B or C, C or D, D or E, E or F, whoever. Okay. All subsequent are assignee, all subsequent are assignee. So, when this burden is going, that is a negative covenant, is going to carry forward to the assignee of the conventor. That means, from B to C, C will be conventor for the D, D will be assignee, D will be conventor for E, E will be assignee, like this, and it will continue. Then it is it will be called as a covenant in equity. Okay. So, the very important case is Talc versus Moxey, in which what was the fact of this case? That in this case T owned a land in London, and this land had a garden surrounded by houses. T sold the garden to E with covenant that E and his successors or assignee will keep the garden intact as garden ornamental and shall not construct any building on it. Okay. So, once it is going to be sold, then this garden must be maintained, it should not be. Whereas, he has not sold the building, that means interest of the building is attached with it, interest of the building is attached with it, because in between there is a garden. So, the T retained that that building, ownership the houses surrounding the garden. After some time, E sold the garden to the another person, who sold it to further to some other person, and ultimately it was purchased by M. Now, M had the notice of the covenant that this is the restrictive covenant, we cannot make anything over it, but he attempted to develop building on the garden. T, enforcing the covenant, sought an injunction to restrain M from the constructing the building in the garden. Okay. And T was entitled for it. Why? Because the covenant what he has created at this time of selling with E, that has been reached up to M, and M is bound to follow, because in agreement itself it was that nothing should be built on the part of the garden. Okay. So, here M will be bound by that. So, court held that in the equity, that in equity all the subsequent transferee were bound by the covenant, and it restrained M from building houses in the garden. Lord Cottenham observed that since M had notice of the covenant and T had legitimate interest in preserving the garden, the covenant was enforceable at equity against M. But suppose the T might have been sold all the property, that means building as well as garden, to E, and that would have been continued up to M. That means all property of that place would have been sold, and this M was M was not residing there. Okay. So, what will happen? Then M will have no right, because his right is not going to be affected, his property is not situated there, he has sold all property in that. Okay. So, he cannot create any kind of restrictive covenant. So, whole property was selling and your interest is not going to be affected by that covenant, then that covenant you cannot put. So, for the restrictive covenant, it is important the transferor right is going to be affected. Okay. Next is contractual obligation annexed to the ownership. Second paragraph of section 40, contractual obligation annexed to the ownership, where a third person is entitled to the benefit of an obligation arising out of contract and annexed to the ownership of the property, then the obligation may be enforced against the transferee for value with notice. So, what we are seeing in this, all these three provisions, that if there is a value, that means for consideration and with notice, then obligation is going to be transferred. Okay. If there is gratuitous only, that means without consideration, then notice is not necessary. Even then this burden will go with that. But if it is consideration and with good faith without notice, then burden will not go, okay, to the transferee. So, always we are seeing this kind of the condition, that where this is for the value with notice, okay, value with notice, that is consideration with notice. So, here it has been said that A contracts to sell Sultanpur to B. While the contract is still in the force, he sells Sultanpur to C. Okay. So, who has notice of the contract? Because C had notice that there is an earlier contract in which A has promised to sell to B, and it was within the knowledge of C itself, then B may enforce the contract against C to the same extent as against A. Okay. So, what A has created this kind of an obligation through the contract, that he would have to sell it to B, but ultimately in between during the force of the contract it has been sold to C. Then A as well as C both will be responsible to fulfill the obligation, contractual obligation, which has been done between A and B. So, B can enforce against A or C as it is. So, a contract for sale of immovable property imposes an obligation on the seller to sell the property to purchaser, but it does not create any interest in favor in the property. Such contracts creates equitable estate in his favor. This is also important. Why? That contract for sale, okay, contract for sale of an immovable property, there is no sale, but only the contract for sale. So, what is the right of the transferee at the time, that means when the sale has not placed, but contract for sale has been happened. So, from the date of contract of sale till the execution of sale or till the sale of happening of the sale, what are the right of the purchaser? Is there any right in that, or only he has an obligation to compel the seller to fulfill that obligation? So, first of all, if third party is not involved, B is that means if the A is seller and B is purchaser, in that case it may be the not only it is a sale, but it may be mortgage and lease also, but I am explaining through this sale example. So, if A is the seller and B is the purchaser, in that case what will happen, that A has that there is a contract for sale. So, in between if the sale is not happened till then, B will have right against A to enforce it. But if in between A has created another instrument, and the person who is creating, person from whom he is dealing, that he had knowledge with that, okay, this property is already a kind of obligation, contractual obligation attached with B. Okay. So, in that case what will happen, that estate in his it says that nor create any interest property to purchase, but it does not create any interest in his favor. Property will not create any interest in his favor, but what it will create? Such contract creates equitable estate in his favor. So, there is no right over the property, no right over the no interest over the property, but only the equitable estate in his favor. So, this restrictive covenants and contractual obligation annexed to the ownership are enforceable when the transfer are for value and the transferee have notice of the restrictive covenants on the property. They are not binding against the transferee for consideration without notice of the right or obligation. So, where there is consideration and there is no notice, and this consideration has been given by the purchaser or the transferee in good faith, then this burden will not follow to the transferee. So, there are few cases, Lalji Jheta versus Kalidas Devchand. This is the case of Supreme Court 1967. The Supreme Court held that the contract of sale does not create an interest in land, but creates a personal obligation of a fiduciary nature. Therefore, it can be enforced not only against the vendor, but also against the volunteer and the purchaser for the consideration with notice. In Abdus Sakur versus Kunwar Munshi Nandlal, the court held that, Allahabad High Court held that the second paragraph confers only equitable title in land on the holder of contract relating to the transfer of land. It does not apply to mere personal obligation to pay money to the third party arising out of contract. So, there is no requirement to pay the money in that case. In case of Basdev Rai versus Jagru Rai, AIR 1924, the court held that the contract giving rise to a right of preemption would create an obligation annexed to the ownership of the property, and this part of section 40 applies to such obligation and binding on a purchaser for value with notice and on the gratuitous, if the transferee was the gratuitous transferee. That means, if the preemption right has been created with the land itself and then it is going to be transferred, then preemption right will also be transferred in that way if these conditions are fulfilled. So, preemption right is also a kind of obligation. Okay. So, in that case, preemption right will also follow to the subsequent transferee. So, it is all about the this section of mainly we have discussed in this about this concept has been already dealt. Three concepts mainly we have discussed in this: restrictive covenants, as well as maintenance, and as well as this limited power of the transferee. Okay. So, three main concepts I have tried to discuss in this part. So, it is all about a kind of restriction on the part of the transferee in different forms. Okay. So, this these restrictions always continue with certain conditions. This restrictions is going to follow in the subsequent cases also. So, it is all about the limited interest transfer as well as the restrictive covenants. Thank you so much.